I walked into the courtroom alone. No lawyer beside me, no briefcase, no reassuring presence to signal confidence or status. Just a folder under my arm and a decision I had made weeks earlier, fully aware that most people would see it as a mistake. The room was already full, filled with low whispers, the soft sound of papers being shuffled, and the quiet tension that always exists before a case begins. A few people glanced at me, then quickly looked away as if they had already decided the outcome before I even sat down. I could feel the assumption in the air before a single word was spoken. A man who shows up without legal representation is usually seen as reckless, unprepared, or desperate. Maybe all three. I took my seat calmly as the clerk called the case. When my name echoed through the room, I stood up. Across from me sat a legal team that looked perfectly organized and confident, surrounded by binders, assistants, and an air of certainty that suggested they believed the decision had already been made. The judge looked directly at me and paused, studying my posture and expression. Then came the expected question. Did I intend to proceed without counsel? I answered clearly and without hesitation. Yes. The silence that followed was brief but heavy. It wasn't laughter or shock. It was quiet dismissal. The kind that settles into a room when people assume they already know how a story ends. What no one in that courtroom understood was that I wasn't there to argue emotionally or make a dramatic speech. I wasn't there to convince anyone through confidence or volume. I was there because of a single clause buried deep inside a contract. A clause most people had overlooked, ignored, or never truly read. That document inside my folder wasn't a gamble. It was preparation. And when the judge finally turned the page and reached that specific clause, the atmosphere in the room shifted. The whispers stopped. The confidence on the other side faded. In that moment, everything changed, not because of emotion or argument, but because the facts were finally seen. To understand why I walked into court alone that day, you need to understand what led up to it. This case didn't begin with confrontation or conflict. It began quietly, with paperwork. Years earlier, I had signed a contract as part of a professional agreement that appeared straightforward at the time. Like most people, I skimmed sections, trusted the process, and assumed the details would never matter beyond signatures and dates. There was no sense of risk then, no hint that those pages would one day decide my position in a courtroom. Over time, circumstances changed. What once felt routine slowly turned into tension, and then into conflict. The agreement I had barely thought about became a source of disagreement. Eventually, I was accused of breaching terms I was certain I had followed. When the legal notice arrived, the language was formal, precise, and intimidating. It was written with confidence, as if the outcome were already assumed. Everything about it suggested the other side expected a quick resolution in their favor. Friends advised me to hire a lawyer immediately. Some offered referrals. Others warned me not to underestimate the situation. Their concern was understandable. Courtrooms are unfamiliar territory for most people, and legal language is designed to feel overwhelming. But instead of acting on urgency, I began reading the contract again, this time line by line. Slowly, something stood out. A section most people would ignore. A clause written clearly, without complex terminology, but with very specific conditions that could not be misunderstood. The more I read that clause, the clearer the situation became. The case wasn't about interpretation, arguments, or persuasion. It was about whether that clause applied and whether anyone would actually read it carefully. I made a calculated decision. Instead of spending months preparing arguments through attorneys, I would rely entirely on the document itself. I understood the risk. Courtrooms are not forgiving places for mistakes, and confidence without preparation is worthless. But the facts were fixed. The ink was dry. The clause existed. What followed was never meant to be a battle of personalities. It was a test of attention, patience, and whether the legal process would function as intended when confronted with its own words. I wasn't preparing to argue. I was preparing to point, to wait, and to let the document speak for itself when the moment came. The first thing I noticed during the hearing was how quickly assumptions form in a courtroom. Before a single argument was made, before any document was read aloud, The dynamic was already set. On one side, a legal team with experience, structure, and visible confidence. On the other, one individual. No attorney, no opening statement prepared. When proceedings began, the opposing counsel spoke first. Their presentation was polished and methodical. They outlined their version of events, referenced dates, and framed the situation as a clear violation. Nothing they said was technically false, but it was selective. They focused on actions while ignoring conditions. Obligations while skipping exceptions. As they spoke, I could sense the room settling into a familiar rhythm. This was a standard case, a predictable dispute. The kind judges see every week. The kind that usually ends the same way. I took notes quietly, not because I needed reminders, but because I wanted to mark exactly which sections of the contract they were choosing not to mention. When it was my turn to speak, the judge asked if I wished to respond. I stood up slowly and said that I did, but not in the way the court might expect. I explained that I did not intend to dispute the timeline presented. I did not challenge the existence of the contract. I did not even deny the actions described. That statement alone caused visible confusion. The opposing counsel glanced briefly in my direction. It was clear they expected resistance, denial, or emotional appeal. Instead, I asked the court for permission to direct attention to a specific section of the agreement, one that governed the exact situation being discussed. The judge nodded and requested the document. Copies were already on record, but the courtroom assistant handed one directly to the bench. As the judge flipped through the pages, I could see the opposing counsel growing restless. This was not part of their plan. Their argument relied on momentum, not scrutiny. I remained silent. I had learned that silence, when paired with confidence in facts, can be more effective than any argument. The clause was there, it had always been there. It outlined conditions under which the alleged breach would not apply. Conditions that had been met. Conditions that were verifiable. When the judge finally reached the section I had referenced, the pace of the hearing changed. Questions were asked, not of me, but of the opposing counsel. Clarifications were requested. Page numbers were cited. For the first time, the certainty in the room began to dissolve. What had started as a routine case was becoming something else entirely. Not because of persuasion, but because of precision. The assumption that I was unprepared had created a blind spot. And in that blind spot, a single clause was about to redefine the entire hearing. The judge did not react immediately after reaching the section I had referenced. There was no expression of surprise, no verbal acknowledgement, no visible signal that anything significant had been found. Instead, there was silence. A long, deliberate silence that felt heavier than any spoken reaction. Pages stopped turning. The room, which moments earlier had been filled with quiet movements and murmurs, became still. I had read that clause dozens of times before that day. Not casually, not quickly, but slowly, line by line, often stopping to consider why each sentence had been written the way it was. It was not dramatic language. It was not hidden behind complex legal terms. In fact, its simplicity was probably the reason it had been overlooked. The clause existed to address a specific scenario, one that most people assumed would never happen. Until it did. The judge leaned forward slightly, reading the paragraph again. Then once more. I could see a finger tracing the lines, not out of confusion, but out of careful verification. Across the room, the opposing counsel shifted in their seats. One of them whispered something to another, likely attempting to reframe the situation before it fully took shape. The judge finally spoke, but not to me. The first question was directed at the opposing counsel. It was a simple question, almost casual in tone, asking whether they disputed the authenticity of the contract version on record. They did not. The contract was valid. It had been signed by all parties. There was no argument there. The second question followed immediately. Did they acknowledge that the clause applied under the circumstances outlined in their own timeline? That question took longer to answer. Instead of a direct response, there was hesitation, a clarification request, a reference to another section of the agreement, an attempt to redirect attention away from the paragraph now sitting at the center of the hearing. The judge listened without interruption. Then, calmly, returned to the clause. The language was clear. It stated that under certain predefined conditions, actions that might otherwise be considered a breach would instead be classified as compliant. Those conditions were not subjective. They were measurable. They depended on dates, notifications, and documented actions, all of which were already part of the case record. I was asked to confirm whether I had documentation supporting my compliance with those conditions. I did not speak immediately. I handed over the folder I had carried into the courtroom. Inside were copies of notices, timestamps, and correspondence. Nothing dramatic, nothing newly created. All of it had existed long before the dispute escalated. The only difference was that now it was being examined in the correct context. As the documents were reviewed, the tone of the hearing shifted again. This time, the change was unmistakable. Questions became more precise. The judge asked about internal procedures, about why certain notices had been acknowledged but not acted upon, about whether internal reviews had considered this clause at any point before filing the claim. The opposing counsel responded carefully, choosing words that avoided direct admission while still attempting to preserve credibility. It became increasingly clear that their case had been built on a broad interpretation of obligation, not on a detailed reading of exception. They had assumed that complexity would favor them. That representation would overpower nuance. What they had not anticipated was that I would remove the usual points of friction. There was no argument about facts, no dispute over timelines, no emotional appeal. The entire discussion now revolved around a single question. Did the clause apply, and if it did, what did that mean for the claim? The judge requested that the clause be read aloud for the record. As the words were spoken in the quiet courtroom, their impact became tangible. Hearing contractual language read aloud has a way of stripping it of assumption. On paper, it can be ignored. Spoken, it demands attention. Each sentence carried weight. Each condition aligned with evidence already submitted. There was no ambiguity left to exploit. I remained silent throughout this process. Not because I was instructed to, but because there was nothing to add. The document was doing exactly what it was written to do. It was not defending me, it was defining reality. The opposing counsel attempted one final approach, suggesting that the clause was intended for a different type of scenario. The judge asked where, specifically, that limitation was stated. There was no answer, because there was no such limitation. At that moment, I understood something important. The power imbalance I had felt at the start of the hearing was no longer relevant. The presence or absence of legal representation mattered far less than the presence of clarity. The clause had shifted the focus away from personalities and back to structure. The judge ordered a brief recess to review the materials in full. As the courtroom emptied, no one looked at me the way they had before. There was no dismissal now. No quiet certainty about the outcome. Only calculation. Only reassessment. The hearing that had begun as a formality was now a problem that needed solving. And when the judge returned, it was clear that the clause had not just changed the direction of the hearing. It had changed its outcome entirely. When the judge returned to the courtroom, the atmosphere was no longer neutral. It wasn't tense in the way people expect from dramatic trials, but it was undeniably altered. The certainty that had framed the beginning of the hearing was gone. In its place was something more cautious, more deliberate. Every movement now carried weight. Every word felt measured. The judge resumed the session without commentary. No summary. No immediate conclusions. Instead, the focus shifted to process. Questions were asked about procedure, about internal reviews, about how the claim had advanced to this stage without addressing the clause that had just been read into the record. These were not accusatory questions, but they were precise. And precision, in a legal setting, often signals that something fundamental has been overlooked. I was asked to confirm dates again. Not because there was doubt, but because confirmation creates a clean record. I responded calmly, referencing documents already submitted. Each answer was brief, factual. There was no advantage in elaboration. The facts were aligned. Repetition only reinforced them. The opposing counsel attempted to regain control of the narrative, by reframing the issue as a matter of intent. They suggested that even if the clause technically applied, the spirit of the agreement had been violated. The judge acknowledged the argument, then redirected it immediately. Intent, the judge explained, cannot override explicit contractual language, unless the contract itself allows for such interpretation. This one did not. That statement alone marked a turning point. Up until that moment, the case had lived in a gray area, where interpretation and persuasion could coexist. Now it was moving into a binary space. Either the clause applied, or it did not. Either the conditions were met, or they were not. There was no room left for implication. The judge requested clarification on one final procedural matter: whether the opposing party had issued a formal notice addressing the clause before filing the claim. There was a pause. A long one. The answer, when it came, was careful. No such notice had been issued. That omission mattered more than anything else discussed that day. The contract was explicit. Before any enforcement action could proceed under the circumstances described, a notice referencing that specific clause was required. Not a general notice, not a warning, a direct acknowledgement of the exception. It had never happened. The courtroom grew quiet again, but this time the silence was different. It wasn't suspenseful. It was conclusive. The kind of quiet that settles in when options begin to narrow. The judge explained, in clear and unemotional terms, that the court could not ignore contractual requirements simply because one party found them inconvenient. The agreement governed the relationship. The clause was part of that agreement. And failure to follow its process undermined the claim at its foundation. I noticed something then that I hadn't expected. The opposing counsel stopped taking notes. Not temporarily, completely, their posture changed. They were no longer preparing arguments. They were calculating outcomes. I was asked whether I had anything further to add. I said no. There was nothing left to clarify. The record spoke for itself. The judge announced that the claim as filed could not proceed in its current form. The reasoning was straightforward. Without compliance with the clause's procedural requirements, enforcement was premature. The case would either need to be withdrawn or refiled following proper notice, subject to limitations already outlined in the agreement. What that meant, practically, was immediate. The pressure that had brought me into that courtroom evaporated. The threat that had loomed for months was no longer active. The legal imbalance had corrected itself, not through argument, but through alignment with the document both parties had signed. As the hearing concluded, there was no celebration. No sense of triumph, just relief, measured and controlled. I gathered my papers, the same ones I had brought with me, and stood as the session adjourned. No one laughed. No one dismissed me. No one avoided eye contact. The shift was complete. The courtroom that had felt close to me at the beginning of the day now felt procedural, almost mechanical. I walked out the same way I had walked in, alone. But the outcome I carried with me was fundamentally different. What had changed wasn't perception. It was position. And position, I had learned, is defined not by who speaks the loudest, but by what is written, and whether anyone takes the time to read it. The legal effect of the judge's decision was immediate, but the practical consequences unfolded more slowly. Court rulings often end with a clear directive, yet what follows is rarely simple. As I left the courthouse that day, the case was no longer active in the way it had been before, but it wasn't erased. It had shifted into a different phase, one governed by limitations, deadlines, and procedural barriers that now worked in my favor. Within days, formal notices began to arrive. Their tone was noticeably different from earlier communications. Where previous letters had been assertive and declarative, these were cautious, carefully worded, and filled with conditional language. The certainty that once defined the other side's position had been replaced with hesitation. Every sentence acknowledged risk. Every paragraph avoided commitment. The clause had done more than pause the case. It had introduced consequences that could not be undone. One of those consequences involved timing. The agreement specified strict windows for enforcement once certain conditions were met. Because the required notice had never been issued, and because time had continued to pass, those windows were now closing. Even if the claim were refiled correctly, it would face immediate challenges, not based on argument, but on expiration. Another consequence involved internal accountability. I later learned through disclosures required by the court that the clause had been identified during early internal reviews, but dismissed as irrelevant. That decision had shaped everything that followed. Resources had been allocated, strategies approved, assumptions reinforced, and all of it had been built on the belief that the clause would never be tested. Now it had been. I was contacted by representatives from the other side, not to negotiate, but to discuss options. That phrase appeared repeatedly. Options. It was an acknowledgement that control had shifted. The discussion was no longer about enforcement. It was about mitigation. I listened. I did not interrupt. I did not respond immediately. There was no advantage in speed. The leverage created by the clause was strongest when paired with patience. Every proposal they presented assumed cooperation on my part. Every concession they offered existed because the original path was no longer viable. What stood out most was how quickly narratives change when structure intervenes. The story that had been told about me, about my obligations, my supposed failures, my alleged non-compliance, quietly disappeared. It was replaced by a new narrative, one focused on resolution, efficiency, and moving forward. The past was no longer useful to them. Only the future mattered. From a financial standpoint, the impact was equally significant. Costs that had been projected as inevitable were suddenly optional. Penalties assumed to be enforceable were now contingent. Even legal fees incurred up to that point became part of internal discussions, no longer framed as justified expenses, but as sunk costs tied to a miscalculation. I was asked, more than once, why I'd chosen to proceed without legal representation. I gave the same answer each time. I had relied on the document. Not because I believed lawyers were unnecessary, but because in this case complexity would have obscured clarity. The clause did not need interpretation. It needed recognition. As weeks passed, the urgency on the other side increased. Deadlines approached. Procedural hurdles multiplied. What had once been a straightforward enforcement action had become a logistical challenge with diminishing returns. Eventually, a formal proposal was presented, outlining terms that would resolve the matter permanently. The proposal acknowledged indirectly what had happened in court. It did not admit error. It did not reference the clause explicitly. But it structured its terms around the reality that enforcement was no longer assured. The power dynamic had recalibrated itself. I reviewed the proposal carefully, not emotionally, not defensively. I compared it to the original agreement, to the clause that had changed everything, and to the position I now held. The question was no longer how to avoid loss. It was how to formalize certainty. When the agreement was finalized, it closed more than a case. It closed a chapter defined by assumption and imbalance. The resolution did not come with apologies or acknowledgments. It came with signatures and filings. That was enough. Looking back, the most consequential outcome was not the legal result itself, but the demonstration of how fragile confidence can be when it rests on incomplete reading. The other side had not acted maliciously. They had acted predictably. They had trusted momentum, representation, and precedent. What they had not trusted was the document in its entirety. For me, the experience redefined how I approached risk. Not by avoiding it, but by understanding where it actually lived. Risk, I learned, often hides not in what is unknown, but in what is assumed to be irrelevant. By the time everything concluded, the courtroom felt distant. The silence, the questions, the pause before the judge spoke, all of it had done its work. The clause had not just altered a hearing. It had altered outcomes far beyond that room. And the consequences, once set in motion, could not be reversed. After the agreement was finalized, there was a noticeable absence of noise. No more letters arriving unexpectedly, no urgent calls, no looming deadlines. The legal pressure that had dominated my thoughts for so long simply stopped. That silence was not dramatic, but it was profound. It created space, not just in my schedule, but in my thinking. What followed was a period of reassessment. When a dispute ends through documentation rather than confrontation, there is no emotional release built into the process. There is only clarity. I revisited every step that had led me there, not to second-guess myself, but to understand how close the outcome had come to being very different. The difference had not been intelligence or luck. It had been attention. In the weeks after the case closed, I noticed subtle shifts in how people interacted with me professionally. Nothing explicit was said, but tone matters. Requests became more measured. Assumptions were replaced with questions. It was as if the existence of that clause, and the fact that it had been enforced, had quietly redefined expectations. The same document that had once been treated as background noise had become a point of reference. I was asked more than once whether the process had been stressful. The honest answer was yes, but not in the way most people expect. The stress did not come from confrontation. It came from restraint. From trusting that silence and preparation would matter more than reaction. From allowing a system to function without attempting to overpower it. Financially, the outcome stabilized more than it recovered. There was no sudden gain, no windfall, no reversal that transformed my situation overnight. What changed was predictability. Obligations that had once been uncertain were now defined. Risks that had been open-ended were now capped. That stability carried its own value, one that doesn't show up immediately but compounds over time. I also became more aware of how often documents are treated as formalities rather than frameworks. Contracts are signed quickly, stored digitally, and forgotten. Clauses are skimmed, not studied. Exceptions are assumed to be theoretical. The experience had shown me how dangerous that mindset can be. Not because disputes are inevitable, but because, when they arise, they follow the path of least resistance. And resistance usually forms where assumptions live. There were no further legal challenges, no appeals, no renewed filings. The window had closed, just as the agreement outlined. Time combined with process had done its work. The system had not favored me personally. It had favored consistency. I kept the folder from that day, not as a reminder of conflict, but as a reference point. It contained nothing extraordinary, no dramatic evidence, no hidden leverage. Just documents that had existed long before anyone questioned them. Their power had come from timing and context, not from revelation. Occasionally, I was asked for advice by others facing disputes of their own. I never offered strategy. I never suggested proceeding alone or challenging representation. Instead, I emphasized preparation, reading, understanding what governs a situation before reacting to how it feels. The most effective decisions I had made were not bold. They were precise. What stayed with me most was how the perception of vulnerability can be misleading. Walking into court without a lawyer looked like weakness. In reality, it was alignment. Every decision I made that day followed a single principle. Let the document speak before I do. That principle extended beyond the courtroom. It reshaped how I approached agreements, commitments, and even conversations where expectations needed to be defined clearly. The aftermath was not marked by closure in the emotional sense. There was no final scene where everything resolved neatly. Instead, there was continuity. Life resumed, but with a deeper awareness of structure. The experience had stripped away the illusion that outcomes are driven primarily by confidence or persuasion. Often, they are driven by compliance with details that exist quietly in the background. Months later, the case became something people referenced indirectly, not as a story, but as a precedent. A reminder that procedures matter, that exceptions exist for a reason, that ignoring them can carry consequences long after assumptions have settled. For me, the most lasting effect was internal. A recalibration of how I measured control. It was no longer about being heard. It was about being prepared. Not about anticipating every possibility, but about knowing where authority actually comes from. In the end, the aftermath did not bring celebration or vindication. It brought confirmation. Confirmation that systems, when engaged properly, do not require force. They require patience. They require attention. And they require the discipline to trust what is written, even when others have already decided how the story will end. That understanding stayed with me long after the courtroom emptied, and it shaped everything that came next. Long after the case was resolved, I realized that the most permanent outcome was not the agreement itself, but the record it created. Legal matters rarely end in isolation. They leave traces, filings, transcripts, procedural notes, all of which become part of an institutional memory. That memory doesn't speak loudly, but it persists. The hearing I had entered without a lawyer was now summarized in official documents. The clause that had once been ignored was referenced plainly, without emphasis, as if it had always been obvious. The decision, procedural and unemotional, sat quietly among countless others. Yet its presence mattered. It established that the agreement functioned exactly as written, and that deviations from its process carried consequences. That mattered not just for me, but for how future actions would be evaluated. I noticed this shift the next time a routine administrative matter arose. The tone of communication was different, not deferential, but careful. Language became precise. References were specific. There was an awareness that assumptions would be tested, not accepted. The system had adjusted its expectations. What struck me most was how quickly certainty dissolves once a record contradicts it. Confidence, when unsupported by process, fades quietly. No one announced that they had been wrong. No explanation was offered. But the behavior changed, and behavior is often the most honest response. The clause itself did not gain importance because of me. It gained importance because it was enforced. Until that moment, it had existed as a contingency. Afterward, it became precedent. Not binding precedent in the broad legal sense, but practical precedent within the scope of that agreement and those involved. It would be read next time. It would be considered earlier. I reflected often on how close that clause had come to remaining dormant. Had I reacted emotionally, hired representation immediately, or engaged in prolonged argument, the focus might have shifted away from the document itself. Complexity could have buried clarity. Instead, the absence of noise had amplified what mattered. There is a misconception that systems favor those who understand them best. In reality, systems favor those who respect their structure. I had not outperformed anyone intellectually. I had not uncovered hidden language. I had simply followed the framework that already existed. The record now reflected that. Months later, when all deadlines had passed and no further actions were possible, the matter became final in the truest sense. Not just resolved, but closed. There was no lingering uncertainty, no conditional language left to interpret. The agreement, once a source of tension, returned to its original role, a reference. I kept thinking back to the moment I entered the courtroom. The assumptions that filled the room had felt heavy at the time, but they were ultimately irrelevant. They were external projections, not determinants. What determined the outcome had been present long before anyone formed an opinion. It had been written, signed, and filed. The experience left me with a quiet confidence, not rooted in confrontation or validation, but in understanding. Understanding that leverage does not always announce itself. That authority does not always appear authoritative. And that preparation, when grounded in structure, can outweigh advantage. When people later asked me what the turning point had been, they expected a dramatic answer. A sentence, a reaction, a decision made under pressure. I told them the truth. The turning point had occurred years earlier when the contract was drafted and signed. Everything else had simply followed. That realization reframed how I viewed responsibility. Not as something imposed externally, but as something negotiated in advance. The courtroom had not been a battlefield. It had been a place of verification. In the end, the record did not tell a story of humiliation or triumph. It told a story of alignment. Of a system encountering its own language and responding accordingly. That was enough. I did not leave with recognition or acknowledgement. I left with certainty. The kind that doesn't need reinforcement. The kind that comes from knowing that when words are written carefully and read attentively, they have a way of speaking louder than anything said aloud. And that, more than anything else, is what stayed with me. I reached the end of this journey knowing that survival is never defined by a single moment,
but by a long sequence of decisions, circumstances, and forces that unfold over time.
Looking back at everything that happened, I understand that what allowed me to stay alive was not courage in the traditional sense, but persistence in the face of uncertainty, combined with factors that were often completely out of my control. Each phase of the experience revealed how fragile normal life can be, and how quickly ordinary situations can turn into critical ones. What stands out most is that survival does not erase what happened. It simply allows the story to continue. The events I went through remain part of my history, shaping how I move forward, and how I understand risk, chance, and human resilience. This account is not about heroism, lessons, or inspiration, but about documenting what occurred as accurately as possible, based on what is known and verifiable. By sharing this experience, the focus remains on the reality of survival itself, stripped of exaggeration or dramatization. This is where the story concludes, not because the impact ended, but because the documented sequence of events reached its final point.